I mean, you cannot fully appreciate the extent of the lawlessness in cities like Los Angeles and Seattle and Portland and New York and the reasons for it until you understand this dynamic. On December 17th of 2013, a 15-month-old girl by the name of Kamaya Flores was found dead with her ribs broken in the home of her father, 25-year-old Darian McWoods. Now, according to medical examiners, the toddler had enough methadone in her body to, quote, slow or stop her breathing. And during McWoods' 3-week trial in Portland, there were a couple of theories that were presented as to how this happened. For one thing, McWoods had a habit of mixing methadone with Capri Suns, so there was a chance that his daughter drank one of the mixtures by accident. Alternatively, prosecutors found evidence that McWoods would occasionally give small doses of the drug to his children in order to put them to sleep. Now, whichever theory you believe, or if you believe some other theory, McWoods was clearly responsible for the fact that his daughter had somehow ingested a highly lethal synthetic opioid. She also had a trace amount of methamphetamine in her blood. And additionally, on top of the methadone and meth in her system, the girl had also suffered, quote, abusive injuries consistent with asphyxia, as well as a laceration of the liver and facial bruising. Those injuries may have been caused by McWoods' habit of, quote, plugging her nose and holding her down until she fell asleep. In other words, Darian McWoods killed his daughter in an extremely depraved manner. There's just no doubt about that whatsoever. And in any sane society, he would have been executed a long time ago. But that's not what happened in this case. Instead, McWoods was sentenced to life imprisonment with the possibility of parole following his conviction for murder by abuse, first-degree criminal mistreatment, and witness tampering. Now, at the time, the grandmother and great-grandmother of the 15-month-old victim told reporters that they were relieved that McWoods couldn't harm any more children and that they finally had some closure. Watch.
We, the jury, duly impaneled and sworn in the above entitled cause, do find our verdicts upon the counts submitted to us as follows. Count 1, murder by abuse, guilty. Count 2, murder by abuse, guilty.
I feel like it's kind of the start of some closure. You know, the healing is a continual process. It's something that just, you never really totally heal over, you know, but it's the start of the closure. And I feel the same relief Raquel does, but I also feel relief that he won't be able to harm any other children. That's a big relief for me.
That footage is from July of 2018. So if you're keeping track, 5 years after Darian McWoods killed his own daughter, prosecutors in Portland finally decided to bring a case and secure a conviction. And the family, belatedly, is relieved that this depraved, evil man is in prison. But the story didn't end there. And what happened next is a case study in how equity and quote-unquote restorative justice works in places like Portland. Even in cases where someone has already been convicted by a jury, and even when their crime is to torture and brutally murder a child, left-wing prosecutors and judges in Portland will still do everything in their power to ensure that the killer is somehow allowed to go free. They do not rest. They do not feel any sense of shame or demonstrate any interest in protecting the public or protecting kids at any point in the process. And that's why, instead of spending the rest of his life in prison, Darian McWoods is going to be a free man in less than 2 years. Yes, you heard that correctly. After killing his own daughter and being convicted for it, Darian McWoods will walk free in about 1.5 years. And in total, he will have spent just a few years in prison for torturing and murdering his own young child. Now, to understand how this happened and how it implicates the entire so-called justice system in places like Portland, we need to go back to 2022, and that's when a court of appeals in Oregon decided to overturn Darian McWoods' conviction. Watch this.
Nearly 4 years to the day after Darian McWoods received a life sentence in the death of his 15-month-old daughter, the murder conviction is overturned. Heard in the Court of Appeals, it was revealed the prospective jury's only 2 black jurors were removed by prosecutors, and McWoods, a black man, was found guilty, producing concerns that underlying racial bias could have had an impact on this case.
Everyone's acknowledging has these sort of baked in or structural biases.
In 2018, McWoods was found guilty of multiple charges, including murder by abuse, after his 15-month-old daughter, Kamaya Flores, died in December of 2013. An autopsy not only found methadone in her system, but also broken ribs and proof of compression, asphyxiation, meaning she was crushed until she couldn't breathe.
It's frustrating to have to go through it again. And it's like ripping a Band-Aid off over and over again.
Her grandmother, Raquel Flores-Volsteak, says she's ready to go through a trial again if she has to, but worries about the impact on her children, including Kamaya's little sister, who she adopted.
The ruling from the appellate court was that McWoods didn't receive a fair trial because during jury selection, the prosecution prevented 2 black people from serving on the jury. Before we get into the specifics of this ruling and how absurd it is, it's important to realize that during jury selection, there are 2 ways that prosecutors and defense attorneys can veto a member of the jury and prevent them from serving. The first possible reason is for cause. This means that the prosecution has to show the person is incompetent or severely biased or unfit in some way. The other way is to issue a challenge. The prosecution doesn't have to explain the reason for this challenge. They can just look at a juror, decide that they have a bad feeling about him, and issue a challenge that gets him kicked off immediately. The catch is that prosecutors and defense attorneys are only allowed a small number of these challenges. In Oregon, for most trials, you only get 3 challenges. That's it. And therefore, you have to use them wisely. Additionally, you can't violate the Constitution, so you can't challenge all of the black jurors simply because you want to discriminate against black people. Even though data suggests that black jurors are substantially more sympathetic to black defendants, you still don't get to kick black jurors off the jury simply because they're black. If the defense thinks you're doing that, they can complain to the judge about it, and they can attempt to reverse your challenge. That's exactly what happened during the trial of Darian McWoods. The prosecutors got rid of 2 black jurors using their challenges, and on the spot, predictably, the defense claimed that racism was involved, but the trial court judge disagreed. He thought that it was completely reasonable to get rid of these 2 individuals. But on appeal, the court in Oregon decided that, indeed, the dismissal of these 2 jurors was racist, and therefore McWoods gets a new trial for killing his daughter. Now, if you read the ruling from the appellate court, you immediately realize what a farce it is. They did not uncover any evidence that the prosecutors had secret racial motivations. They didn't uncover that, the prosecutors were posting on some secret KKK message board or something. Instead, the appellate court determined that some white jurors were allowed to stay on the jury, even though they gave somewhat similar answers on their questionnaire as the 2 black jurors who got kicked off. And therefore, the appellate court inferred that the prosecutors must have been motivated by racism. That's it. That's their entire justification for throwing out this conviction. This logic, such as it is, falls apart the moment you realize that answers on jury questionnaires are just one of many ways the prosecutors can size up a potential member of the jury. Another way is to look at them. And that's what happened in this case. Here's what the prosecutor told the trial court judge right after issuing a challenge against juror number 6, who's a black man. Quote, "Frankly, he showed up to jury service wearing a shirt that says, 'I have issues.' I don't know what that means, but that in and of itself is also concerning to the state." Yes, the black juror showed up with a shirt reading, "I have issues." That's how he walked into the courtroom for jury selection for a high-profile murder trial. Now, in looking online, I found a few potential matching T-shirts that would fit this description. And you can see some of it there. There's a lot of Deadpool stuff, but also more generic "I have issues" shirt, as you can see. In any event, whatever this shirt looked like exactly, and we don't know exactly which shirt it was, it's a safe bet that juror number 6 should not have been seated on the jury for this reason alone. There are really only 3 options to explain this guy's decision to wear this shirt to trial. The first option, of course, is that he actually does have issues, in which case he's admitting to being disqualified. The second option is that he doesn't really have issues, but he wants to get out of jury duty, so he wore that shirt as a way of doing that. The third option is that he's an adult man wearing a Deadpool T-shirt to court because he's actually an overgrown child. And in all these cases, juror number 6 clearly should have been tossed immediately. This is a trial for a man who's killed a child. We need serious adults, serious people on the jury to deliberate and look at the evidence, not guys who are wearing stuff like that. And that's not even getting into the fact that on his jury questionnaire, he stated that it was, quote, possible that he might, quote, self-impose a higher standard of proof in a murder trial like this one. And we're also not getting into the fact that on his questionnaire, the juror said that he agreed with the statement that, quote, DNA evidence is unreliable. Keep in mind, juror number 6 was the only juror in the entire jury pool who admitted to the prosecution that he didn't trust DNA evidence, which seems like a valid independent reason to kick him off the jury in this case if you are the prosecution. This month, Tax Network USA proudly celebrates our nation's birthday, honoring freedom, resilience, and financial independence. To mark the occasion, they're offering 10% off all services through July 4th. If you're dealing with back taxes or you missed the April 15th deadline, don't wait. The IRS is rapidly stepping up enforcement. Penalties can add up very quickly, up to 5% per month, maxing out at 25% of your total tax bill. And that's just for not filing. And that's on top of what you already owe. But there's good news. Tax Network USA can still help you turn things around. Whether you're self-employed, run a business, or your books are a complete mess, their team knows how to cut through all the chaos and find solutions that actually work. Your consultation is always free, and getting ahead of the problem now could help you avoid harsh penalties, wage garnishments, or surprise bank levies. Take the first step. Call 800-958-1000 or visit tnusa.com/Walsh. And don't forget, you'll get 10% off all services through July 4th as part of their celebration of our nation's birthday. Regain control of your finances with expert help from Tax Network USA. And again, it has nothing to do with skin color whatsoever. The same is true for the other black member of the jury who was kicked off. That's juror number 9. And here's the reason the prosecutors issued a challenge against him. Quote, he leaned towards strongly agreeing that he believes that in our criminal justice system, innocent people are routinely being found guilty. And then yesterday, he indicated that he was more likely to excuse behavior if the child was injured due to reckless conduct as opposed to intentional. There was quite a long discussion about that issue, and he was one of the few that actually volunteered and commented on a distinction in his mind between looking less concerned about conduct that occurred recklessly versus intentionally injuring this child, close quote. Again, we have a clear way to distinguish juror number 9 from all the others. He engaged in a long discussion in which he said that he would excuse reckless behavior instead of intentional behavior, while also repeating propaganda about how the criminal justice system is biased or whatever. So prosecutors had a very good reason to get rid of this guy as well. And that's exactly what they did. But on appeal, a 3-judge panel in Oregon concluded that the prosecutors must have been motivated by racism. Concerning juror number 6, the judges simply pointed to the fact that other members of the jury had turned in similar questionnaires. They completely ignored his T-shirt and his comment on DNA evidence being unreliable. And concerning juror number 9, the judges ignored the entire conversation about recklessness. Here's what they wrote in their opinion, quote, with respect to concerns about statements made by juror number 9, we cannot conclude based on the record that juror number 9 responded as the prosecutor argued he did. In other words, the appeals court said it couldn't verify the conversation, so they're just going to pretend it never happened. They're going to infer that the trial court judge, who was actually in the courtroom witnessing all of this, must have been wrong somehow. And then they're going to accuse the prosecutors of being racist, primarily because they happen to exclude the only 2 black people who were around during jury selection. So they're not going to, they won't trust the conversation because they weren't there for it. And yet they can infer this invisible motivation, based on reading the minds of the prosecutors. So that they can confirm, but not the conversation that the judge was there for. The statement says, quote, the plausibility of the state's race-neutral reasons for excusing an otherwise qualified black juror decreased with the second challenge. That implausibility is evidence of purposeful discrimination, close quote. This is, so their judgment that it's implausible that you could have legitimate reason to get rid of 2 black members of the jury is itself evidence of a competing claim that they were motivated by racism. So there are so many problems with that logic. It's not logic. That doesn't work at all. Just because one claim to you in your mind is implausible, which it isn't. There's nothing implausible about finding reasons to get rid of 2 jurors. But even if it was, that in and of itself is not evidence for this other claim that you have no evidence for whatsoever, which is that they're racist. Now, this is yet another manifestation of the left's tendency, which you may have noticed by now, to infer racism simply on the basis of disparate impact. If something affects black people, then no matter what, it has to be racist. If you can ascertain that it affects black people in some case, in some circumstance, more than it affected white people, then it has to be racist. There cannot be any other possible reason behind it. And the people who are responsible must be white supremacists. That's how they approach every situation like this. They work their way backwards from there to rationalize their pre-existing conclusion. They start with the conclusion that any disparate impact must be racism, and then that's where they begin, and they work backwards from there. And that's what the appellate court did there. But only one judge wrote this opinion, and I want to give you one guess. With everything you've heard, when you think about the judge who was on this panel, who wrote this opinion, what do you think this judge looked like? Let's a little thought experiment here. Close your eyes and try to picture this judge's appearance. She just threw out a child killer's conviction because the prosecutors dismissed 2 black members of the jury who were obviously unqualified. She's claiming that it's racism. She wants to put a black child killer back on the street. What do you come up with? Now, if you have any capacity for pattern recognition whatsoever, you probably don't even need me to show you the photo, but in case you do, here it is. You can look at it right there. And again, you just knew she would look exactly like this. It was never in doubt. The most unspeakable atrocities and hideous evils the world has ever seen are supported, encouraged, and facilitated by women who look exactly like this with that exact haircut. And this case is no exception. Now, this particular iteration of the gay feminist destroyer is named Judge Jody Mooney. She's a proud member, of course, of the LGBT plus community, which is another thing you could have guessed. When she was appointed to the bench by the governor of Oregon back in 2019, she stated, quote, "I'm firmly committed to following the rule of law in a way that supports a diverse and open society." She added that laws must be, quote, "enforced equitably." Not equally, equitably. And with this case, Judge Jody Mooney illustrated exactly what equitable enforcement of the law looks like. She's bringing some diversity to the streets of Portland in the form of child killers. Now, at the same time, to be as fair as possible to this judge, who has since retired, by the way, she didn't actually secure the release of Darian McWoods. She made that possible, but what she did was she threw out his conviction and sent it back to the lower court for a new trial. And, if you're kind of a naive person, you might think, well, that's not necessarily a huge deal because the new trial is guaranteed to have the same result as the first, given that this guy definitely, absolutely murdered his child. There's no doubt about that. Certainly, as you saw, the family members of the victim anticipated that there would be a new trial and that this child killer would be convicted again with a new jury, but that's not what happened. Instead, prosecutors in Portland used the opportunity to give Darian McWoods a plea deal. He simply had to plead guilty to manslaughter and criminal mistreatment. And in exchange, he gets to leave prison in less than 2 years. To be clear, there was no reason for this plea deal. It wasn't as though some critical piece of evidence had disappeared or some other piece of evidence had appeared that they didn't have before. They just offered it out of the blue. One of the lead prosecutors who offered this deal was Multnomah County Chief Deputy District Attorney Amanda Nadel, and we'll put her picture up on the screen as well. In a statement following this plea deal, Nadel remarked, quote, "In her short life, Kamaya brought so much light and love to her family. Since her death, her family has remained steadfast in their commitment to ensuring justice was brought for Kamaya. I'm grateful that Mr. McWoods took accountability for his role in Kamaya's death by pleading guilty to manslaughter in the first degree and criminal mistreatment in the first degree. I hope the finality of this resolution will provide closure to the victim's family." That is one of the most sadistic statements you will ever see, especially after watching that footage from the family that we played earlier. This is closure, is letting the killer out of prison in a couple of years. That's how justice works in Portland. Multiply it by a dozen different Soros DAs, and you get a sense of how the left-wing prosecutors conduct business everywhere all the time. Even when they secure convictions in high-profile murders like this one, doesn't last very long. They wait until the media attention dies down, and then they sabotage their own cases. I mean, you cannot fully appreciate the extent of the lawlessness in cities like Los Angeles and Seattle and Portland and New York and the reasons for it until you understand this dynamic. The most heinous crimes imaginable mean nothing to these people. All that matters is creating disorder. They know their power depends on it. And the case of Darian McWoods demonstrates once again that nothing, not even the torture and murder of a child, is going to deter them. If you'd like to see what else I have to say, you can access my full show by going to dailywire.com or by going to the Matt Walsh Show Twitter page. Hope to see you there. Godspeed.